of action. I don't know whether he's asserting it or not, but that based on allegedly improper advice.
The complaint, and I'll ask him when it's his turn, but are public records and untruthfulness. I mean, that's what they're titled.
That's it, but it's a whole...
I understand there are allegations.
Right, that's true. And again, I mean, there's a lot of gray allegations, so to speak, and we have to kind of address that. I mean, he is a pro se plaintiff, so we don't know if those are claims that he's actually making or whatnot, so we kind of had to address it. But to make it simple, public records and the untruthfulness, again, we think the untruthfulness should be dismissed. Public records, the claims for monetary damages should be dismissed. He says that he's not seeking monetary damages, and then the next sentence he'll say that he's seeking a fine or a refund. He's not entitled to that. There's also claims in there relating to a public records request that was litigated before Your Honor and already dealt with the appellate court. We think that that is barred by collateral estoppel. He's saying he's not raising this issue, but yet there are allegations about why those exemptions are not good still in that complaint, and that should certainly, at least then he has a public records claim based on that. Public records request from October 2015, that should be dismissed. If I just can have the court's indulgence on a couple more minutes.
Well, I do have another case at 10:30.
Okay. I think our pleadings set forth pretty much everything. I think the three initial public records requests that were made that form the basis of this lawsuit, we've produced all the documents already. One of the requests deals with delay. The request number 1 that was made in 2017, that the statutory amendment precludes him from any further relief. And he's not entitled to costs, not entitled to fees. We produced those documents. That is clearly new. The June 5th, 2016 request, which is request 2, and the November 2nd, 2016 request, which is request 3. He's alleged and stipulated in various different orders that we produced those documents. We produced those documents timely. He's saying that the fees are excessive.
Counsel, I have to let
Okay.
I'm sorry.
Okay.
And next time, if you want to reserve more time,
Yes, Your Honor.
All right.
Hello, Your Honor. Thank you for letting us be here today. I guess if you want me to, if you want to ask me some questions, that's fine, or I'll just kind of go through in order of his discussion.
Are you making a public records request under the Miami-Dade County Home Rule Charter?
No, sir. I made the request under 119,
Okay.
and then I later found that the Home Rule Charter also has the same requirements, so I guess I'm naming it under the Florida Constitution 119 and the Home Rule Charter. If the Home Rule Charter can't be applied, I have no problem canceling that out. That's no big issue for me.
Okay.
His first point, it actually is not very accurate. He's saying that all my records requests are to the city. I file records requests to the city for records of the city, and I file records requests to WSH and Zeskind for their records specifically. Under the law, it's very clear that he is an agency. They're acting as city attorney. They have taken over a public function to the exclusion of the city, and public records law follows because of that. Whether it's in an individual or official capacity, to me, Your Honor, I'm a pro se. It was a little bit confusing. I kind of probably think his argument towards the individual capacity being stricken is correct. Whether it's individual or official capacity matters not to me. What I care is who the injunction names. And as they noted in Florida Rule of Civil Procedure 1.610C, the rules for injunctions, it says that every injunction shall be binding on the parties to the action. There are parties to the action, and while I understand the argument about naming individuals in their official capacity is redundant and equivalent to naming the municipality, my understanding is that's for damages, to make sure you don't double damages. I want to make sure that they're named on injunctions, and if any of the individuals leave and go seek employment elsewhere, I'm afraid that they could continue to commit these abuses and not be enjoined. So that's why I want the law firm, the city, and the employees individually named. I would have never named the city except for some of the what I am alleging to be violations were done through the city, and I don't know what individual is responsible. For ones where I know the individual that's responsible, I have named the individuals.
What about the advice issue?
I was going to get to that. On the advice issue, it's really not about advice. I understand if somebody hurts me or some person talks to their attorney gives them bad advice, and that leads to me being damaged, my claim is against the person who did damage to me. That person, it's up to them if they want to sue for malpractice their attorney. That's not the issue here. The issue here is records requests were directly sent to Zeskine, and he refused to act on them. And as well, I believe that their actions, or the totality of their actions, are criminal, Your Honor. In Florida Statute 838.
Okay, let me stop you there. If it's criminal, Catherine Fernandez-Rundle is the one that you need to talk to about that. That has no applicability, and there's a case, I don't have it off the top of my head, that says the standard in a criminal case has no application in a civil public records request lawsuit.
I understand, Your Honor. I'm not trying to bring criminality in. I'm just saying the statute itself says that they can't conceal records or let other people, or cause other people to conceal records. I plan to eventually file complaints criminally, and I wasn't trying to bring that up in there. I wanted to explain as to why, because I don't agree that they're named because of giving their clients bad advice. The next thing, we were talking about breaking up the counts. I understand that counts are supposed to be split up. I disagree with their argument that I commingled the counts. Each count is for a pattern in practice. To get an injunction, you have to show a pattern in practice. You have to show multiple violations. So if each of my counts is for an injunction and for a pattern in practice, it has to show several violations. If you'd like me to split it all up and say 1, 2, 3, but I don't know how I do the pattern in practice count, I can split it up. If Your Honor, if you prefer that, I have no problem doing that. I think that just increases the work and obfuscates the issue, since we're going for pattern in practice counts for the injunction. Next, I'd like to talk about the home rule for untruthfulness and the Zeskine and the litigation privilege. I absolutely understand litigation privilege bars any torts that come about from actions that happen inside of litigation. There is one case I provided a copy inside the documents I gave you. It's Deberkamp v. Fisher. And I'll pull this just so I kind of approach the bench real quick. I can show you which one it is.
Okay.
It's the fourth document in front of, here, I'll try to have this on, make it as nice for you as possible. It's the second one right here.
Which number is it?
At the very beginning, it should be the third or fourth document stapled. I'll show you. Don't look right here.
It's Debrin Cat,
One.
EBRINCAC versus Fisher.
Thanks.
And President Council has a copy of this. I agree this is somewhat weak, Your Honor, and I might be misreading the law. I've highlighted a few things in the front. The issue is, there was a case, Wolfie Foreman out of the 3rd District. In that case, it extended the litigation privilege to include the filing of a complaint. And by doing such, it basically barred any malicious prosecution or abuse of process claims. Deberkamp v. Fisher overturned it. And in this case, it wasn't just that it was a malicious prosecution for filing a claim. The person who filed for malicious prosecution got added as a party in an